so let's start with the doctrine of separation of powers. So could anybody now explain to me within your own words, what is the doctrine of separation of powers? What does it talk about? What are you talking about? Anyone? Go ahead. Okay, so give me a moment. Somebody just raised their hand, but I'm gonna look in the chat real quick. So three arms of government being the judiciary, executive, and legislature. Okay, but go ahead.
The doctrine of separation of powers is basically the concept that there should be a clear demarcation between the three arms of government, the legislative and the executive and the judiciary.
Lovely. So the legislative, right, the judiciary, and the executive are what Aristotle would have called the deliberative, the magistracy, and the judicial. Right, so we're gonna start with the historical background of separation of powers, and then go into the Westminster system, right, and then look at specifically the separation of powers within the Commonwealth Caribbean constitutions. So the historical background now, right? So we know the doctrine of separation of powers is a principle, a political theory that was stated out for the division of governmental authority, right, among different branches to prevent the concentration of power by a single entity. So it is promoting, what this is promoting, right, is some amount of, well, it's really separation, right, that is promoting. It's promoting the dissemination of power, the distribution of power, because usually, right, at the time within the 1700s there about, right, before around 1730s to 1740s, before the French Revolution, and just after the the English Golden Revolution, there were monarchies that spread across Europe, and all of these monarchies had absolute rule or absolutism, where one man or woman, in the case of Catherine the Great of Russia, right, one man or woman would have been the sole person who had all the powers, legislative, executive, and judicial powers within one person, right? So looking at that, the Leviathan. Not sure if anybody is interested in philosophy, right? But we're looking at this, right? So the political philosophy behind here is to try to stop all that power being established or being enshrined within one specific entity or person. So they divided the power to prevent absolute rule and the abuse of that power, right? So John Locke was a very important person, right? In this case, there was an English philosopher, right? And he often cite in this he was a 17th century philosopher, and he's often cited as one of the intellectual architects of the doctrine of separation of powers. His influential work, Second Treatise on Government, right? These things are really important to me because when I was doing political philosophy at UE, right, we had to read through all of these different things and look at all of them from all perspectives, right? So looking at this now, the second treatise of the government, right, the main emphasis on this was basically how government should be structured. He had a really profound thought of how government should be structured. And he has a quote here. So Locke argued here now that for the protection and of individual rights and the need for limited government, right? He argued that, right? Protection of individual rights and the need for limited government. He advocated for the separation of powers between the executive, legislative, and judicial branches to prevent any type of tyranny. Locke emphasized the importance of checks and balances, stating that, right, in his own words, the legislative cannot transfer the power of making laws to any other hands, for it being but a delegated power from the people. They who have it cannot pass it over, right, to others, right? They who have it cannot pass it over to others. So looking at what it's saying here, right? He was also a very important proponent as relates to social contract, saying that the people give the government the power to make good laws for the good governance of the people, right? And we're looking at that. So in order to actually make sure that no one entity has all the power to know exact all of their ultimate power and tyranny upon the people, he's want to separate it, right? So only one section should be making the laws, and the other section should not have that power, right? The other section should have different powers that keep those law making powers, the legislative powers, in balance, right? So Locke's ideas laid the groundwork for later formulations of the separation of powers, right? We also had Montesquieu, right? So he was a French philosopher. Charles Louis II Baron de Montesquieu further developed the concept of the separation of powers in his influential work, The Spirits of Laws, in 1748. Montesquieu argued that liberty is best perceived when the governmental powers are divided and balanced. He proposed the separation of powers into the legislative, executive, and judicial branches, with each branch having distinct functions and acting as checks and balances to others. Montesquieu famously stated, "When the legislative and executive powers are united in the same person or body, there can be no liberty at all, because apprehensions may arise, lest the same monarch or senate should enact tyrannical laws to execute them in a tyrannical manner." This is Montesquieu in his work, The Spirits of Laws. So it's basically saying, no, if the executive and the legislative were in one body, right, that would be too tyrannical. Because the legislative makes laws, the executive approves them. If you make and approve your own laws like that, right, you cannot make and approve any law. So it'd be completely tyrannical. So we're looking at the creation of systems that allow for government to be held in balance. So Montesquieu's idea greatly influenced the drafting of modern constitutions, right? So he helped draft the Constitution of France, the Constitution of the United States, the Canadian Constitution, the Constitution of Australia, all of the different constitutions. Majority of the first world constitutions that you're seeing here, you're seeing the works of Aristotle, John Locke, and Montesquieu. Separation of powers come from these philosophers. These are the origins of separation of powers, right? And most definitely, Commonwealth Caribbean constitutions have the influence of the French and the English philosophers, right, within their separation of powers doctrine. The Westminster system now. Let's have a discussion about this. The model of parliamentary democracy derived from practices in the British Parliament. That is what the Westminster system is described as, right? So it's a parliamentary model derived from British principles or British traditions, right? So we have parliamentary sovereignty in the Westminster system. The parliament is the supreme legal authority and its decisions are binding. This means that parliament has the power to make or repeal laws without interference from the other government branches, right? So they make and repeal laws, right, without interference from other government branches there, right? We're looking at that. Obviously, within the Commonwealth Caribbean countries, we're gonna have the executive that would actually vet those laws, right? The bicameral legislature. Many Westminster system countries have bicameral legislature, right? They're not monocameral. I think is Guyana. I don't remember if it was Guyana or Trinidad that was monocameral. They don't have an upper and lower house. I don't remember which country it was. Could you guys remind me in the chat? Right, but usually we have bicameral legislature where we have a House of Commons or called our lower house, and we have the upper house or the House of Lords. So the lower house is typically more powerful than and is where the government is formed. Right? So looking at there. House of Representatives, etc. Right? So the bicameral legislature. Right? The fusions of power now, unlike strict separations of power found in some other systems, the Westminster system has a fusion of powers between the executive and legislative branches. The executive government is drawn from, well, and accountable to the legislature, right? So remember, it's the parliament, the prime minister generally within our countries, right, or the president, I guess, right, would have formed the parliament, right, and then selects the executive. So remember that their members are selected from parliament that are used to create the executive, right? So that's why we're saying the executive branch is drawn from the legislature, right, and it is used to keep the legislature in balance. They're responsible for implementing laws and policies, right? So policies are usually dealt out by the executive, and laws are usually dealt out by the legislature. That the cabinet government now, the executive branch, is led by a cabinet composed of ministers chosen from the majority party or a coalition in the lower house of the parliament, right? The prime minister is usually the leader of the majority party, right? Heads the cabinet and holds significant executive authority. Why do we use the word usually? Because the monarch, right? The monarch itself, right? So usually in our constitutional monarchies existing across the Caribbean, or in some cases the president. Well, in some cases the president, but the monarch itself, right? So let's say the crown in this case, right, has the duty to select a prime minister that is representative of the majority party in parliament, right? But the monarch can actually just decide, who is prime minister. The governor general can do that in the absence of the part of the crown. So they do have differences there, right? So we're looking at the fact that the monarch can actually they actually appoint the prime minister. It's actually appointed, right? So you could have vote till a week, right? If the monarch wanted to appoint a specific prime minister, that is the prime minister that will be appointed, right? But usually they're just going to appoint the prime minister that won the vote, right? Because that just makes sense. Why would you just create unrest in a country by choosing a prime minister that didn't win the vote, right? That's just unrest. But yeah, so the appointment is done there. Okay, so somebody asked a question in the chat. Let me see if I can view it now and answer it. So the rules of each organ state and the rules can overlap. Okay, lovely. So you could please repeat the differences. Okay, so the executive, right? The executive. Okay, let's see. Legislative, right? The legislative is there, right? Legislature, right, is used for the making laws, right? Legislature processes, right? They make the laws and they send it to the executive, and the executive would be the ones who look through the laws, right, to make sure that they make sense, right, and then up reaffirm the laws. The laws. So remember, right? The laws are made generally within the lower house, right? And they are sent to the executive now to be approved, right? The executive is also important for the creation of different types of policies, right? So policy management is important for the executive as well, not really legal management. Go ahead.
That's good.
Go ahead.
Good day, sir. Really sorry to interrupt your class. I'm on, and I appreciate the fact that you take your time to share with the students in preparing for their examination. So just a point of clarification.
Okay, go ahead.
The legislator is the one who actually makes the law. Remember that the legislature is both the House of Representatives and the Senate, and all laws are created, amended, repealed in the legislature. The executive is just really the government, right? The ministers who creates policy and governs the country. So it's not that the legislators or parliamentarians, the laws are debated or introduced in those houses, and then it goes to the executive. There's a there's just a slight correction there.
Okay, thanks for clearing that up.
Okay, thank you, sir. Appreciate what you're doing as well.
No problem. Right, so yeah, so thank you for that there, right? So generally, right, just in case I've been like just in case it was foggy, right, at the start, right? So the laws are made in parliament specifically, right? So we have that there because the parliament, the legislature, as the name is given to it, has the legislative power, right? The power to create different forms of legislation, whether it be primary or subsidiary, right? And the executive would be there for the creation of policies and maintaining, right, the governance of the country, right? So those are generally the two main differences between there. So hopefully that properly answered the question in the chat. Alright. So the responsible government now, the ministers are collectively responsible to parliament, right, for actions of the government, right? So they must maintain the confidence of the lower house, and if they lose confidence, they may be required to resign or call for new elections. Right. Now this is not as common as we normally see it, right? But we know the executive, right, are generally the ministers that are brought out of chosen from the legislature, right? So generally what we're looking at is for the good governance of the country itself, right? If there is not good governance, if the parliament and the people itself has lost the confidence of these ministers, right? Usually there is some amount of pressure for them to resign and stuff like that. We've been seeing those things throughout the Caribbean history, right? Looking at the fact that if there's an issue or a scandal or something, or the minister is just overall ineffective and leading to more detrimental effects, right? Then that will cause these ministers to actually have to resign, right? Be required to resign, or to call for a new election for a new minister to be placed in that spot, right? So there must be some amount of responsibility by the government, right, for the good governance of the people, right? Generally, or these pressures will be exacerbated, right? So it kind of rings a bell when it comes to the social contract as well, right? I'm not sure why within the Cape Law syllabus we don't really speak about the social contract a bit more explicitly, but it's a piece of really what happens there with the social contract, right? With the separation of powers in and Commonwealth Caribbean constitutions now, right? We're supposed to be looking at that, right? Picking it apart, right? So while the Westminster system features, right, a fusion of powers, it still has some amount of degree of separation of power, right? There's still some amount of separation of the function. The executive, legislative, and judicial branches are still apparent within the Westminster system. So the parliament is responsible for making laws, right? The executive branch is responsible for implementing the laws and creating different types of policies, as well as administrating government affairs. And then we have the judiciary now that interprets and applies the law, right? So we look at judicial interpretation when we're doing module 1, right? And they also apply it in different cases, all right? So those are really the separation of how the separation functions, right? So we have that there. So the checks and balances now, right? We know that there's no strict separation between the mechanisms within the Westminster system, right? There is not always a complete strict isolation of the different parts, right? So there is always a system, always a slight overlap that allows for different sections of government, right, to actually keep the accountability of the other sections, right? So the parliament would exercise oversight over the executive through processes, right, such as question time, parliamentary debates, and committee inquiries, right? So the parliament can actually keep the executive in check. Additionally, the judiciary acts as a check on both executive and legislative branches, right, ensuring that these actions comply with the laws and the constitution itself. So there are a system of checks and balances within the separation of powers to make sure that no one branch is overstepping, right, contributing to a breach of the doctrine of ultravirus, right, or being or doing anything unconstitutional, right? So we've always had that amount of checks and balances that exist, right? And there are constitutional limits as well. So within the Westminster system countries, some countries that have these systems, right? There are constitutional provisions that limit the powers of the government and protect the individual rights. And we spoke about this when we were talking about constitutional supremacy, right? So there are provisions such as the Bill of Rights, right? Judicial review, right, of legislation is there. Entrenchment is there. We spoke about all of these different things, these principles, right, that cannot be or is difficult for Parliament to override, right? So we're looking at these things that keep each section, right, under the separation of powers, right, accountable. Okay, so let's look at these limitations, right? So we're looking at constitutional limitations specifically, right? What's happening here, right? So looking at the need for cooperation. So let's look at this. So we have different cases here where we see instances of the executive having been given a legislative function that was declared unconstitutional. Here we have J. Astafan and company versus the Controller of Customs and the Attorney General of Dominica, right? So in this case specifically, right, we had the executive actually taking out some legislative functions, right? And it also follows John v. DPP 1985 and Hines v. R. right? So it actually follows these cases, right? So Heinz v. R was another issue there where the executive, right, meted out some of the functions of the judiciary, right? And in this case now, we have the executive taking out some of the functions of the legislative, right? So hopefully we should be able to look at this case here, right? So the case is there. So for DPB versus Mollison now, right, we had an issue within the Juveniles Act, right, in 1951, right. There was some amount of scrutiny, right, by the Jamaican courts here. So it's another Jamaican case, DPP versus Mollison 2003, and it was basically speaking about juvenile detention, right? So basically, a governor, right? So it's the provisions of the statute allowed for the governor to allow some amount of discretion to determine the sentence of a juvenile, right? So it's similar to that of Heinz v. R. So DPV versus Mollison is similar to that of Heinz v. R, in which we had the executive sentencing someone, right? Or having some amount of role to play in sentencing, right? Which is done by the judiciary, not the executive, right? We also have some issues, right, where the courts does not intervene in lawful exercises, right, or decision making, right? So we know that the court, right, generally is not supposed to be exercising, decision making powers for the executive, right? They're not supposed to be making laws specifically. Technically, they're not supposed to be making laws, right? So an exercise of we have judicial review to do that, right? So where there's exercise of unlawful power, right? There's a remedy of judicial review available, and that is really described within Sharma versus the DPP of Trinidad and Tobago, right? So looking at that, so the chief justice of Trinidad and Tobago was the actual person, the appellant, right? So looking at that, so those cases had those key principles to deal with, right? So the J. Astafan case was about the executive taking on legislative function. DPP versus Mollison was about the executive taking on judicial function, right? And within Sharma versus DPP et al., right, what we have here, right, is decision making by the judiciary, right, as opposed to the executive. So we're looking at breaches within separation of powers. These are the cases that look at those. All right, the main cases that look at those. All right. For the independence of the independence of the judiciary now, we know that there's an amount of judicial independence, right? And it's one of the main cornerstones of democracies or democratic government, especially under the rule of law. So within Commonwealth Caribbean countries, right, there's some amount of independence of the judiciary that is enshrined within these constitutions, right? The independence is vital, right? So it tries to prevent any type of biases that could be exemplified within the judiciary, try to prevent any type of bias, right? By making sure that the judiciary, right, is generally members of the judiciary, right, are appointed generally through specific processes, right? Their payment is done or enshrined within the constitution to make sure that no type of system can actually control the judges, right? So we're trying to make sure that there's have some amount of independence so they can actually exert their power in making sure that the executive and the legislative branches don't overstep, right? So if the payment and all of these different things and the appointment was done by the legislative specifically, right, then there would be less separation of powers because one branch would be completely controlling another. But what we're looking at here is that the branches are specifically independent of each other, and especially the judiciary. In the judiciary, that is the most important, right? So we'll look at that. So the judiciary are the constitutional safeguards, right? They're the safeguards of the Constitution, specifically within Commonwealth Caribbean constitutions, right? These provisions in the Constitution, right, helps to secure the tenure of the judges, help to ensure that they cannot be removed from office except for specific reasons through a rigorous process, right? And their salaries and benefits are protected, right, to prevent interference or influence from executive or legislative branches, right? So this is crucial for the function of judiciary, right? So a judge cannot just be fired because they made a decision that you don't like. They cannot be fired that easily, right? Their salaries are controlled, so you can't, let's say, underpay them or stop paying them or do any type of issues or draw any strings as it relates to money, because that is enshrined, right? That is something that is protected, right, within these legislatures, right? You can't have the executive and the legislative, right, ruling over the judiciary, because the judiciary is the one that keeps them in balance. So they have to be independent of each other, right? So looking at the appointment part processes as well, they are primarily, right, the appointment procedures of judges are primarily designed to minimize any type of political influence and to ensure merit-based selection, right? Primarily, I use the word primarily because we're looking at the law as it ought to be, not necessarily what it is. Right, so this is important for the establishment of an independent judiciary, right? So it's the appointment procedures are free from political interference, right, and usually merit based, right? Judicial immunity and protection is present as well. So judges can often enjoy immunity from civil lawsuits for actions taken, right, in the course of judicial duties, right? So while they're undertaking their judicial duties as defenders of the laws and constitution, right, they have some amount of immunity, right? Protection from harassment or pressure related to their decisions, right? So we're looking at that. You can't just sue a judge because they made a decision that you don't like, right? The judges are actually defended from, protected from these things, right? So the judiciary may have the authority to review the constitutionality of laws and government actions, providing a check on the legislative and the executive branches. We also have the separation of powers there, and we spoke about it in depth, right? So the rule of law and public trust is also a very important thing here, right? So a strong and independent judiciary leads to the entire society upholding the rule of law and maintaining the public trust in the legal system. So when the public sees that the judges are doing everything independently, right, and not being swayed by politicians, right, are not being under the complete power and rule of the executive, we can note that the judiciary is doing its job, right, to the best of their ability without any type of, especially political interference or biases. So that increases the public trust within the justice system. So when citizens believe that the judiciary is impartial and free from political interference, they're more likely to respect the court's decisions. So we're looking at that, the rule of law and public trust, right? An important case here is Emmanuel versus the Attorney General 1989. That's an important case there. What occurred in this case? Anybody knows this case? So what's happening here? We're looking at the chief magistrates of Dominica, right? Looking at that there. So the chief magistrate of Dominica was recruited by the government, right? He was employed on contract, right? Which was provided for him, right? And he was terminated at any time within a month's notice, right? So the contract provided, right, that he could be terminated within any time within a month's notice, right? When the contract ran out, it was not renewed by the government, right? And he brought a case towards the courts. So what we're looking at here, right? He's arguing the non-renewal of his contract amounted to wrongful termination because the contract had been altered by implication of the Constitution, so as to provide him with the security of tenure. So because he was a member of the judiciary, right, he cannot be just dismissed like that. That's what he's saying, right? He can't be dismissed like that. Based on the Constitution, you can't just hire a judge like that, and you can't just terminate a judge or dismiss a contract like that, right? So we're looking at that, the legal termination of the magistrate, right? So we're looking at this now. what occurred here. Nobody, I don't know if anybody knows this case. So what this basically was doing, right? The termination of his post was subverting administrative justice, right? The administration of justice, as it relates to the fact that the magistrates engage themselves in fixed terms of years, with their contracts terminable forthwith as a plaintiff's case and without any reason, right? What we're saying is that he's terminated without any reason. Remember that that members of the judiciary cannot just be sent out or terminated without a rigorous progress, or not progress, rigorous process rather, right? So it cannot just be tossed aside like that, right? What we're looking at here is legitimate expectation, right, as well as infringements on the constitution with the independence of the judiciary, right? But we're gonna understand this case a little bit more when we talk about the rule of law and understanding how that works with legitimate expectation, which is a part of the natural justice part of the rule of law topic, right? We're gonna talk about it, right? So we have that to really look at. Okay. So somebody please remind me to bring back to the Emmanuel v. Attorney General case. Right, we're gonna have a look at it when we talk about the rule of law or legitimate expectation, then we'll look at what's happening there. Okay? So that's generally it for the doctrine of separation of powers for my review there. Alright.